If you've been offered a suspended imposition of sentence in a current charge you have, you need to understand what that means. A suspended imposition of sentence, often referred to as an SIS, is a disposition in a criminal case. It's an agreement between the parties or with the judge, wherein a person will plead guilty as charged to a crime, but they will never be sentenced if they do the appropriate conditions. The reason why an SIS is attractive to some is that the goal renders you without a criminal record. To fully understand this, you need to understand where your criminal record comes from. A criminal record attaches at the moment you are sentenced. Hence, if there's no sentence, there's no criminal record. What happens in court is an agreement between the parties, where one person pleads guilty. The case is then held open for usually 2 years, and during that time, certain conditions need to be met. Often those conditions include staying out of trouble, perhaps doing classes, sometimes it's an alcohol assessment and treatment, sometimes it's paying back restitution, maybe even community service. At the end of the 2 years, as long as all the conditions are met, the case is closed without a final disposition. With no final disposition, there's no sentence. With no sentence, there's nothing to attach to one's criminal record. Hence, the best thing about an SIS, or a suspended imposition of sentence, is to save you from having a criminal record. That said, all the conditions have to be met. You'll still pay a fine, and you'll still have to go through the process, but it is a great mechanism for those who just cannot have something on their record. For additional information, feel free to give me a call at 636-486-1093. And I'll remind everybody to please be careful about signing paperwork in court without understanding what you're getting into.